What's up, everybody? Kartik Subramaniam over at Avi Schools. Wanted to give you a quick coronavirus update that the California Association of Realtors has put out a coronavirus addendum or amendment to the purchase contract. Now, there's a concept in business law or contract law called force majeure. And a force majeure clause is basically a clause in a contract or a legal theory that says if there is some crazy delay that prevents me from fulfilling my end of a particular bargain, that I can invoke this force majeure clause to basically get me out of performing on a contract. So you might argue that if I'm buying a property, the fact that there is an economic pandemic that could lead to a financial meltdown, this might excuse me from performing. And this coronavirus amendment really is designed to kind of clarify the rights of the parties. If you kind of look at this, you can argue, and again, I would encourage you to consult with your legal counsel about this if you're in a purchase agreement with someone. There are three possibilities, well, four really, but you can look at the form on the screen. There are three outlined outcomes if you incorporate this coronavirus amendment in your contract. Now, the first one is that the buyer and seller agree to postpone the close of escrow by up to 30 or some other number of days to accommodate unforeseen circumstances, after which either party may cancel the agreement and the buyer gets their deposit back. So in the first option, we agree to postpone the escrow for up to a certain number of days. And if I'm not able to close escrow within that number of days, that the buyer gets their deposit back. It says no notice to perform is required. Now, a notice to perform is basically where one party tells the other party, hey, you got to do what you said you were going to do, usually within 2 days. And if you don't, I can cancel the agreement. Long story short, if you choose number one and don't check 2 or 3 in this document, the buyer and seller are agreeing to postpone the close of escrow by a certain number of days. And if they can't get it done within that extra number of days, that the deal falls apart and that the buyer gets their deposit back. That's one option. The second option, if checked, so you have to check this one if you want it, buyer and seller agree that the buyer may not have their loan contingency in place anymore. A loan contingency, of course, is a period of time where the buyer can cancel the transaction if they can't get their loan wrapped up. Number 2 says, look, even though the buyer doesn't have that loan contingency anymore, if the buyer can't fund their loan because, let's say, they got laid off or whatever it is because of coronavirus, then either party can cancel and the buyer still gets their deposit back. So if you check number 2, you're saying, hey, the buyer may not have the loan protection anymore in the contract, but still, if the buyer can't get a loan, even though they remove the loan contingency, that the buyer still can get their deposit back if a loss in income is due to the coronavirus. Number 3, if checked, we're saying that, hey, the deal died and the buyer gets their deposit back. So it's interesting in numbers 1, 2, and 3, the buyer's deposit is protected in all 3 by default. Now, of course, there's a 4th section in here that's just a bunch of blank lines. If you're a realtor, you know that most of these standard form agreements have blanks in them that you can sort of fill in and kind of do whatever the parties want. But the 3 options here, if you invoke the coronavirus amendment, number 1, we're agreeing to extend the escrow for a certain period of time. And if we can't get it closed in that period, we can cancel the deal, buyer gets their deposit back. Number 2, even though the buyer doesn't have a loan contingency anymore, if the buyer can't get their financing because of a loss in income due to the coronavirus, the buyer still gets their deposit back. And number 3, of course, the deal is dead. Now, it's interesting because you might look at some of this and say, hey, this seems like we're offering the buyer some additional protection, and it's maybe extending some of those periods, but why would the seller agree to that? Well, if the seller is, I guess a couple things. First, if the buyer's saying that, hey, I'm claiming a force majeure event, so I get my deposit back anyway. So the seller and the buyer might not want to litigate that. So we might just say, hey, look, we're agreeing that we'll extend the escrow for a period. And if the deal can't get done in that prescribed period, that buyer gets their deposit back. The other thing is, if I'm selling my house right now and I've got it in escrow for $1.5 million, and I see all this stuff in the news about the stock market dropping and real estate going this way and all this sort of thing, I might tell a buyer, look, I'm willing to be more flexible with you, Mr. and Mrs. Buyer, because I want you to close my deal at our price rather than having you bail. And even if I keep your deposit, let's say the contract allows for that, I might get it back on the market and I might lose even more money if the market starts to go sideways or drop a bit. This coronavirus amendment is a very useful tool given the economic environment today. Now, it's very important that if you're going to use this, you consult with a licensed real estate broker and an attorney if you think that to decide whether or not this is something that you deem appropriate in your transaction. I can't stress that enough, because every deal is going to have different elements and different circumstances and a different fact pattern that will determine whether or not this is something you want to invoke. But as always, wanted to just kind of keep you updated on what's happening in the real estate market these days. It is a very interesting time to be kind of processing all this. So I hope you're well. Hope you're practicing social distancing and following what the CDC is saying to do. And we'll catch you guys on the next video. Thanks.